I want to begin my speech with the word of the Prosecutor General of Brescia at the conference organized in the last October. We, honorary judges, are the first people citizens encounter when they go to the court. In the normal course of things, matters concerning citizens and matters which are dealt with only by the honorary judges. A claim for damage, for a road accident, or a dispute with a neighbor, a claim for reimbursement for a delayed flight, are all matters which are dealt with and decided only by the honorary magistrate. So, if a citizen is brought to a trial for death, injury, or fraud, the person who will be facing the prosecution and the trial will be an honorary deputy prosecutor, and the one who will decide will often be an honorary magistrate. Here, the citizen, when he is in front of us, does not think to be before a lower court, does not distinguish between career judges and not. For that, citizens are the ones who administer judges, and in fact, we administer justice, without difference with the ordinary judiciary. And we pronounce sentences in the name of the Italian people. This brief reflection, so I wish shall bring us to the topic that I want to talk about, because it was necessary and no longer procrastinable to reach a reform to the honorary judiciary of long course. We have just here the troubled history that led us to the law of number 51/2025, which by a strange coincidence came into force on the 1st May, precisely the date that considers with the Labor Day. Yes, because we are workers. We have always been workers, and now finally been recognized and inscribed in a law of the state. The law is a governative initiative, make change to a discipline of the honorary justice already in force, by introducing provision aimed at revision to the legal, economic and social security regime of honorary magistrate, also to respond to the observation made to the European Commission by Italy with the opening on infringement procedure for violation of worker rights of honorary magistrate. The new law 51/2025 apply only to honorary magistrates who were in service in the time of entry in force of the law 116/2027, regulation sanctioned by the Europe, and who, following an evaluation procedure, have been confirmed in their duties, and these magistrates are also called confirmed magistrate or established magistrate. We. The new law introduced a revisal for legal, economic and social regime of honorary magistrate, regulating both the working relationship of those of choice they exercise exclusively or not exclusively of the function. In practice, the law intervened on the regulation of the employment relationship of the honorary judges, dictating rule of the exclusive function and the not exclusive function, and apply to the new collective labor agreement to the subdivision central function. The President of the Court for Honorary Magistrate and the Attorney of the Republic at the Court for the Honorary Deputy Prosecutor will define the work program of the Honorary Magistrate in accordance with the guideline drawn up to the Supreme Council of the Judiciary, taking into account to the need of the total time to include both activity to be carried out by the hearing and those preparatory and the sequent to hearing itself and the training activity also. The limit is set on the weekly working time, which comes differently from Europe, and the protection of honorary magistrate. The maximum working time is 26 hours per week for exclusive magistrate and 16 hours per week for other judges. The rule then introduces a rule of incompatibility for confirmed magistrates who have adopted for exclusive regime. This provision is identical to that for the ordinary judges. The law also regulates the matter of the competence of the honorary magistrate, listing those which are excluded, so that all other matters fall within the competence of the honorary judges. The law also provides that in case of temporary needs of emergency situation, the honorary judges may be assigned to compose the panel. As regards the honorary deputy prosecutor, they will continue to perform the function of public prosecutor by delegation of the Attorney of the Republic, but for all judgment before the Justice of Peace and in the court, except those expressly reserved by the law for the ordinary magistrates. It was also introduced a regulation on holiday that provides that honorary magistrates do not serve during the work period. However, if there are specific requirements of the office and the honorary magistrate work during this period, they are entitled to recover his leave in another time. For the first time, is introduced the possibility for the honorary magistrate to request a transfer to another place in certain criteria are met. The new assignment is made by the decree of the Minister of Justice after a favorable decision of the Superior Council of the Judiciary on the proposal of the autonomous section for honorary magistrate of the Judicial Council. The new law also regulates the procedure of assessing professional competence, which will be carried out every 4 years. However, unlike career magistrate, aptitude assessment do not lead an economic transfer to a higher salary level. A specific graduate disciplinary liability regime has also been introduced, ranging from the serious failure to perform the duty of the office to case of minor gravity. The remuneration provided for the activity of honorary magistrate is defined autonomously, compared to the previous one that parameterizes into the treatment of the administrative judicial personnel. This compensation is treated in the same way of the employees, and the reform introduced a special amendment to the lay tax. An important milestone active that is introduced of the provision that ensure the honorary magistrates against accident at work and occupational disease. In addition, the honorary magistrates are registered with the pension fund for employers and the following form of social security: insurance for invalidity, old age and survival, insurance against involuntary unemployment, health insurance, and maternity insurance. Finally, honorary magistrates are granted a meal voucher if they exceed the 6-hour period of the present at the judicial office. So that's all.